Just for the benefit of the audience, the topics are first, the definition of corporate insolvency, second, valuations and asset sales in insolvency, and third, non-liquidation insolvency proceedings as compared to liquidations, which is a huge topic, for a very long time. So I just kick around a couple of ideas and pass the mic on. On definitions of corporate insolvency, I think we've seen today that we basically share two insolvency tests: the cash flow test, the balance sheet test. I think that the important thing, really, the important policy question is obviously what do those tests serve for? I mean, what does the system use them for? One answer might be to test solvency for the purposes of actually making management subject to a strict duty to file, which I think among us is most pronounced in Germany, where there routinely is not only civil or risk of civil sanctions, but criminal enforcement, something which we've canceled in this country a couple of years ago because the criminal justice system was not able to deal with that at all. And from there, the question is, does it really make sense to make management subject to a strict duty to file? And I suppose that depends on what you think about how your formal insolvency system can deal with the insolvency situations and whether it is likely to generate or save more value than destroy. I think that jurisdictions differ on that markedly. This jurisdiction, the Czech Republic, sort of pretends that it wants debtors to file as soon as possible, but nobody is really sure that the system really can save more value than destroy. And I would say that the strict duty to file is not really strictly enforced here. As I've said, we've had a crime of non-filing in good time, which we've canceled into 2008. We have got a very draconian possibility of a civil liability, but we really, to this day, haven't got any meaningful cases. So the system as such is not really able to process the threat, I think. And that puts, and that brings up a third question mark of, are you able to create a alternative out-of-court system or an alternative out-of-court culture that wouldn't put the strain on the formal systems, on the formal institutions, and yet somehow keep the moral hazard on the part of managements and shareholders in check. There is a initiative by the European Commission announced last year in exactly that direction, and that's one other topic that has a bearing on the tests of insolvency, because any system that tries to nurture informal methods of solution of financial crisis must set aside the hard duty to file, at least for some time in the first place, because otherwise the managers cannot really try to attempt an informal solution if they are pulled the other way by the strict duty to file. Valuation and methods of sale. I think that the Czech experience shows that if you do not have a developed culture of valuations, a liquid and strictly policed market for valuations, courts that can police that, you can get some horribly ridiculous valuations. And because the valuations are really important in all instances, but in particular in non-liquidation cases, where the assets really do not meet the market test ever, possibly, then this can be a real Achilles heel, to any non-liquidation system. Because if you do not put the assets on the market, you don't know their market value by definition. Yet you need that, certainly in any system that allows security. And if you cannot rely on the system to produce reasonable valuations, you will have difficult problems. And that relates to how much non-liquidation proceedings can your system handle. I mean, yes, liquidations can be destructive, they can be dangerous, there's a lot that can go wrong, but I think that our experience of 10 years with a non-liquidation type of proceedings is that non-liquidations can be very difficult to police. They create huge moral hazards on the part of management, on the part of equity, especially in concentrated equity ownership systems like ours. And the question is whether your institutions, mostly the courts really, will be in place to police those conflicts and to police those moral hazards. And I think that this country is just about on the verge of managing, but it quite often doesn't. So that would be my opening thoughts on those three topics.
I have to admit these topics are not very close to my field of experience, but still, if I look at this from the risk management point of view, I think it's very good that all the experts also who are present here are trying to find a way how to quickly or how to identify the moment when the company can be, or the company assets can be saved by identification of the moment of, let's say, bankruptcy of the company. Because since that moment, measures can be implemented how to save these assets, and either by implementation of, for example, a better monitoring system in terms of maybe monthly monitoring of financial results, or increased supervision of such companies. So the owners or shareholders of these companies would not be allowed to strip the assets quickly and without noticing by, for example, creditors. I believe that there must be some, let's say, criminal threat of, or let's say the people who commit either fraud or some financial crime has to see that they are not, or they will be punished at the end if they try to do this. This is something what we see in general in our countries, in Slovakia or Czech Republic at the moment, that the law enforcement is not so effective, and these people, from my experience, are not afraid to do wrongdoings because they don't tend to adjust or they are not afraid to, or to prefer to get rich as compared to lose their freedom. And if they see that there is some penalty, some harsh penalty, if they see that there is strict supervision, if they see that the law enforcement is working well, they would probably not be tempted to do so. And this must be also medialized. People and either public or experts should demonstrate how it goes in bankruptcies. They should make public be aware of what can happen to people who did wrongdoings, and also threat all potential fraudsters. Let's not do this, because we have implemented some measures and we will be strict if you don't follow the rules. So maybe I will pass it further.
Okay, so from the Polish perspective, I would like to limit myself as regards the first and second question to just a brief remark, because I addressed some issues from those questions during my presentation. As regards the first question, I would like to emphasize the starting point of bankruptcy proceedings in Poland, which we faced during our recent reform, where the yearly number of bankruptcy proceedings opened in Poland hovered around 1,000, sometimes less, sometimes more, which is in a country which is almost 4 times as big as the Czech Republic. So it meant quite clearly one thing, that the bankruptcy proceedings were barely used. In most cases of insolvency, the proceedings were not opened. And going to the definition of insolvency, so the cash flow insolvency, we had this unrealistic 14 days deadline to file for insolvency, together with this generally accepted but in fact wrong approach that you are insolvent when you don't pay two debts, two invoices. So the judges were telling that actually almost all filings by the debtors were late, which made all these instruments of liability of debtors and of managers, all those sanctions applicable against manager, a very selective instrument, because on the one hand you needed to have really bad luck to get hit by it, because like 99% of cases with late filings or with non-filings, non-sanctions were applied at all, but once the sanctions were applied, they were quite painful. What we tried to do with the reform in Polish law is, on the one hand, to make this definition of insolvency and the deadline more realistic. So as I have said in my presentation, now it's this presumption that 3 months delay only triggers the presumption that the debtor is insolvent. The delay for filing is additional 30 days. So it is still too early to say whether it has changed the situation much. So the law applies for a bit less than 1.5 years. And another structural weakness of Polish insolvency system is that there are barely any statistics collected beyond some research projects done by universities, which are limited to some part of the situation. They don't give an overall view. So that's one thing, that actually it was an effort to make insolvency work in bankruptcy proceedings in a very on a very basic level. So to make it from an instrument that was barely used, an instrument that will start to work on a let's say will start to be used more frequently. The second issue which I would like to address, it's the last question, so the remediation methods for solving bankruptcy, so alternatives to liquidation, mainly restructuring. So it was actually the main purpose of the Polish reform, the introduction of restructuring proceedings. Again, based on very bad experiences with previous efforts. So previous effort of reorganization proceedings introduced in 2003, it was just an example how not to transplant solutions from other legal orders into Polish law. In 2003, reorganization proceedings were introduced during the last phase of legislative work on the then bankruptcy code, just because our then finance minister took part in a conference, probably in UNCITRAL in New York, heard about brilliant ideas about reorganization, and told, okay, we need to have it. So, and the drafters got like 2 weeks to draft provisions from scratch. It was duly passed, entered into force. The number of cases opened under those provisions went slowly from 20 per year to 0 in the last year of the application of the cases. I have to say our current reorganization proceedings are more successful. So currently the number, from the overall number of insolvency proceedings, the number of reorganization proceedings starts to approach half of them. So almost half of them are reorganization proceedings, a bit more than half are bankruptcies, with one important caveat. There are actually, which is closely related to risks that Tomasz has referred before. There are more and more voices that at least some of those proceedings are being abused or misused to as a delay tactic, so to give debtors some protection from enforcement proceedings for some time. And obviously it is still too early to say, we only know stats about opening of proceedings. It is too early to say how many of those proceedings are successful in long term, so they manage to restructure the debtor and to maintain the existence of the debtor's enterprise. Thank you very much.
Yeah, the systems to recognize if a company is illiquid or not. In Germany, we have a lot of systems to control that. Normally, one times a year, we make a balance sheet like in your countries, and the going concern principle is the main fact of all. If you have a going concern remarked by a business administrator, then you have no problem with your capital. You only have maybe a problem with your liquidity, and this cases you don't know once a year. Every month you will see it, and when you don't have enough money to pay all your invoices, then you go to the bank, and the bank said, okay, let me see how good is your company, and then we came to you with in Germany it calls S11 or S6 at first. S6 is the standard for reporting, and I think you will talk something about that after my speech. And when the bank don't get the going concern principle, the bank is not able to give new money. In this case, the company must go into the insolvency. But my view on insolvency right is not the view just only for the debts and to say how many money or how much money I can get back from the poor company. My view on this case is to restructure the companies. But when you see the huge amount of insolvencies every year, I told 20,000 insolvencies in Germany, and you was really impressed about this number, because in Poland we have 4,000.
4,000 consumer bankruptcies.
1,000 company insolvencies in Poland, and 4,000 from normal human beings. In Germany, we have 130,000 humans and between 21 and 26,000 companies. Just only 4% have the chance to make an insolvency plan, because the normal board of the company isn't able to produce that. It's absolutely too complicated, and so the most of all insolvencies was handled as an asset deal. Just the assets were for pricing, and then someone come and buy it in all, or maybe also in parts. But what is the value of a company? Is it the machine? Is it the land? Is it the flat? I think the real value of a company are the processes. You spend a lot more money in processes to bring a company into the fashion to have a good product onto the market. And the machine is just only a thing you can buy or not. The processes you have formed about months and years. And so when you just liquidate a company in parts, the processes were gone. And with this destroying of processes, you will destroy the most value of the company. So I feel the ability just to see we need a less complicated insolvency right in Germany for smaller companies, and a huge professionality of insolvency administration for the bigger one. So I think this could be the good way, and just we have in Germany now 20 years, nearly 20 years, a new insolvency right, and we make some good steps, but maybe not enough steps to come into a new version of treatment of insolvencies.
First of all, when we talk about the definition of corporate bankruptcy, our recommendation would be make it simple, make it clear, make it transparent. As my colleague just said, it's often too complicated, and especially for the, let's call it, normal managing directors who are not faced with those problems on their day-to-day business. It's way too complicated, it became way too complicated, and the law should be so easy that everyone can cope with it. So the definitions may be the illiquidity or the over-indebtedness. Everything should be clear, transparent, and as easy as possible. We all know that totally easy is nothing in the world, and the reality is much more complicated than the law. But if it is transparent to everyone, and if every normal managing director knows what it means, that would help a lot. When we come to valuation and methods of sale and enterprises, and that's the valuation issue is always a big problem. In Germany, we have the discussion that the over-indebtedness should be abolished out of the insolvency law, because it's always complicated on how you value assets, what is a liquidation value, and especially if we then, I mean, it's easy if you have only 2 machines, 1 car, and cash on the balance sheet, but in reality, you normally have several subsidiaries, you have divisions who are profitable, etc., etc. And we all know that valuation, it's not really the cash flow in the end, it's more the interest rate that we discount the cash flow that determines the value. So the effect you can have is huge, and in the end we have years over years in discussions whether the company was in over-indebtedness or not, and then you have expert opinions. The insolvency administrator has 3, the management has 3, and they all come to different results. So also this should be clear and easy to understand for everyone. Therefore, I'm a big fan of the illiquidity solution, because illiquidity is much more straightforward than the over-indebtedness. And to the last question, we were discussing the whole day about insolvency proceedings. I always want to remind that insolvency proceedings should always be the last resort of everything, because for most creditors, for the employees, for whoever, shareholders, and whoever is involved in a process like this, once we open up formal insolvency proceedings, it's always worse for all the participants. Doesn't matter if employees, creditors, or whatever. So we always should try to achieve an out-of-court solution and an out-of-court restructuring, and have the formal insolvency procedures only as backup. As you all know, we have this draft directive from the EU Commission at the moment for a preventive restructuring framework in Europe, which I think is a good idea. But if you really read it and if you compare it to what we do already at the moment in consensual restructurings that are out of court, it's more or less, we have those proceedings already, just that we can, at the moment we need the consent of all creditors, and maybe with this new framework we need only the consent of 75% of the creditors. But in the end, I would always recommend try to restructure the company out of court without insolvency proceedings if possible. It's always the best solution for all participants, and only if it's really necessary because the law requires it, then we have to go into in-court proceedings. And then in the first step we have what we in Germany have for a couple of years now. Is it either the debtor in possession proceedings or whatever, but at least try to restructure the company and get a viable corporate structure out of it, out of the process through an insolvency plan or whatever. And what we saw in the past, the liquidation within insolvency proceedings, this should really be the big exemption in the future, because there are always viable parts in the company. Of course, sometimes in the end there remains a non-viable asset or part, and this needs to be liquidated. But this should really be the last resort in the end. Thank you.